I want to say good morning, everyone, and thank you for attending our OSHA Vaccine Mandate webinar today. My name is Katie Hetherington-Cunfer, and I'm GRCA's Director of Government and Community Relations. We have assembled local experts to talk about the OSHA Vaccine Mandate and offer tips on how to best manage this and COVID-related issues with your workforce. Today, we'll be featuring two speakers. We ask that everyone who is not a panelist, please mute your microphones for the duration of the presentation. This is being recorded. We will be hosting a Q&A after both panelists have concluded their remarks, so please write your questions in the chat. If your question is directed at a particular speaker, please note this. We will also be sharing a recorded copy of this presentation with all registered attendees following the event. To start, I'd like to welcome Laurel Cline. Laurel is the Vice President, Senior Human Relations Consultant for Herbein Mosteller HR Solutions. She'll be offering some tips and strategies for businesses to effectively communicate these difficult and complex issues with your employees. I often refer to this as verbal judo. So I like to say that Laurel has a black belt in this field, and so she'll give us some good tips on how to handle. So welcome, Laurel, and thank you for sharing your knowledge with us.
Terrific. So Kevin and I spoke yesterday, and he was intending to give his remarks first because they definitely have an impact on mine. So spoiler alert for Kevin's remarks. As many of you probably already know, I noticed I see some human resource professionals on this webinar, and many of you, like me, get the updates on where the ETS and vaccine mandate stands, and Kevin's going to talk about that at some length. But essentially, Kevin and I both agree that there's not much likelihood at this point in time that that ETS is going to ultimately be successful, and in whatever form, if it is successful, there will definitely be a time frame for folks to to be able to implement. So Katie, I do have some slides if I'm able to present.
All right, I've made you a co-host.
Okay, perfect. So I will try to share my screen here. I don't think we'll do that. Bear with me one moment. Yep, that's not working. Sorry, technical difficulties here.
That's okay.
Okay.
There we are.
Okay, not sure what the trick was with that, but so wasn't even sure really what to title this, because honestly, I think as we said, this is something that's been gone back and forth a number of times. So communicating with employees. Really, if you choose to communicate with your employees now about the vaccine, I think the important thing to do is just simply, talk with them. Most of them already know that there's a potential for a vaccine mandate. If you're going to communicate with employees at all, at a minimum, let them know what it might mean. This is what the regulation talks about. This is what it could mean for us as an organization. But again, based on Kevin's comments, I don't know that that's really necessary at this point. Given the potential for the politicizing of this issue, I think it's important to let employees know that the approach that you want to take, the approach that's important for everyone, is that this is a workplace safety issue, and that ultimately, as the employer, your goal is really to keep people safe, and that's the focus of any kind of communication that's going to be going on. If you choose to, at this point say, hey, okay, we believe that maybe, oh, Kevin's here. Kevin, would you like to jump in and do your piece first?
Well, if you have a breaking point that you can get to, that would be fine. I don't want to.
I'm good to break.
Okay, all right. Sorry, everyone. Had an emergency there in the building. I know we have a nice full house this morning. Good morning, everyone. If you've been following national news and you're a constitutional law nerd like me, there's been a lot of reading in the last few days. And, my piece of this session is going to be largely emphasizing the law and how courts are reaching their decisions, because I think it's instructive for everyone as you keep an eye on things. As Laurel and I discussed yesterday in our prep session, her advice is going to be far more practical to you going forward. I can provide you sort of with the legal layout. And right now we're dealing with a couple of different things. First, we'll focus on the OSHA Emergency Temporary Standard, which was enjoined by the Fifth Circuit Court of Appeals back in November. And procedurally, those cases have been consolidated to the Sixth Circuit Court of Appeals for disposition. To give you a little background, these were filed by private litigants and state governments. And just to add some flavor to the mix, there were specific cases filed in what were perceived as democratic-friendly jurisdictions, claiming that the OSHA Emergency Temporary Standard was not strong enough. And that was, frankly, a strategy in the hope that the lottery system that is used to designate the court that handles the consolidation would pick a court in that friendly jurisdiction. I can tell you that the record of the Sixth Circuit is not friendly to the administration and the positions. Historically speaking. Another procedural point to address is many of us have heard cases that were heard by a 3-judge panel and cases that went, instead of going to the next level court, they would go to a full panel or a full body of a court. And that's called en banc. And that just means all the judges. There's a procedural step that you can take to request that the entire court hear something if it's important enough. It's got to be important enough and intended to save the time associated with having a 3-judge panel issue a decision and then having an immediate motion for reconsideration by the full court. So that's also been taken here. I don't believe we have a decision yet as to whether the full Sixth Circuit is going to take up the OSHA Emergency Temporary Standard case, but I expect it to happen, that it will be heard by the full court just to basically save time. Whether they issue a decision before the effective date, we don't know, but I'll tell you what, I nearly spit out my coffee the other morning when I read the Fifth Circuit decision, and it's instructive for these reasons. So the very first sentence of the judge's decision by Judge Engelhardt talks about June of 2020. So for a moment, everybody place yourselves back in June of the year 2020. Okay, no vaccines yet, right? We're in the throes of the pandemic. And at that point in time, OSHA, who we know is the government agency responsible for imposing, safety standards, lockout, tagout, and all sorts of other workplace requirements. Back then, OSHA, quote, reasonably determined that an emergency temporary standard was not necessary to protect working people from occupational exposure to infectious disease, including COVID-19, okay? So this circuit judge now basically hung OSHA by its own comment to start off his decision, and basically saying, this is what you folks said in the throes of the pandemic. What's an emergency temporary standard? Exactly what it sounds like. You know, OSHA is the administrative agency responsible for carrying out and enforcing the Occupational Safety and Health Act. And of course, it promulgates regulations. Those of you who are fellow members of SHRM, you all know through our certification courses, the difference between I'm just a bill and I become a law, and what is a regulation, and further, what is an executive order. So here we had something even different. This was an emergency temporary standard, an emergency rule used as a shortcut in very, very serious emergency situations. In fact, this agency had only ever used it 10 times in the last 50 years, to give you an example of how rare such action takes place. And in fact, 6 of the 10 were challenged in court and only 1 survived. So you have the friction and the give and take, if you will, of the different branches of government and the judiciary acting to stem the tide of overreaching by the administrative agency, that being within the executive branch, when they use regulations or regulatory authority outside of perhaps congressional intent. So that was the real meat of the case. Now, the judge had to decide, you know, all of the factors of what's necessary to impose a stay, an injunction. Again, those of you who follow this stuff, we have notions of a threat of irreparable harm and demonstrating reasonable likelihood of success on the merits. And let me stop there for a second. Anytime you hear an injunction against a regulation, what that means is the court is stopping something from taking effect pending something else, pending a hearing on the merits, a trial on the merits, notice and review, pending other activity. As a practical matter, that's the legal effect. But as a practical matter, that tends to drive other things like withdrawal of a regulation, withdrawal of legislation, a regrouping by the executive branch, because it's likely they may lose at trial. Because an injunction pretty much says, if you're the plaintiff, you're saying, I can win this case at trial, Your Honor, and I have such good proof right now, we don't even need to have the trial. Give us the relief for these other reasons right now. So it definitely puts the executive branch back on its heels when an injunction occurs. And, you know, put aside politics for a moment. You know, this is the circuit court. So the only other right of appeal from the Sixth Circuit's decision will be to the U.S. Supreme Court. So there's not a lot of room to go any further. As a practical matter, a procedural matter, the Biden administration, OSHA said they were stopping just last week. They're stopping enforcement of the vaccine mandate. And that to me, I read tea leaves sometimes. That to me says they know they're going to lose. You know, my legal analysis of this case and others suggests to me that the Sixth Circuit will uphold the Fifth Circuit injunction, will adopt it, the decision, and the Biden administration OSHA ETS mandate will likely not go into effect. I'm going to call that one today. I'm pretty sure I'm right, and I'm not the only one who thinks that. But that's important for all of you because you're trying to figure out how to manage at the office. And again, that's why I said I think Laurel's advice is going to be far more practical than mine. So, you know, I just want to touch upon a couple other things because the court went into great detail. This is a 22-page decision. And, you know, the court alleged that the mandate made it a rare government pronouncement that it is both over-inclusive and under-inclusive. Over-inclusive because it applies basically all across America, even to your long-haul trucker who is on isolation. Under-inclusive because it does nothing to protect people who work at an employer under 99, right? So it was an excellent analysis of the breadth of rulemaking and the exercise of authority. Obviously, folks, the OSHA statute does not expressly authorize this agency to engage in what is largely a healthcare policy. Okay, and I want to talk about the extraordinary power of an emergency temporary standard. The statute that allows OSHA to do this, I'm just reading from the judge's decision. What OSHA did was they bypassed notice and comment, which is what you're required to do for regulations. It did that for 6 months to take immediate effect if it determines that employees are exposed to a grave danger from exposure to substances or agents determined to be toxic or physically harmful, or from new hazards in the workplace. Okay, that sounds more like OSHA's jurisdiction, right? And that the emergency standard necessary to protect them from the danger. Okay, so pretty narrowly drawn, all right? And the court says this, I'm going to read this quote. The judge says, but the mandate here is anything but a delicate exercise of this extraordinary power. Quite the opposite. Rather than a delicately handled scalpel, the mandate is a one-size-fits-all sledgehammer that makes hardly any attempt to account for differences in workplaces and workers that have more than a little bearing on workers' varying degrees of susceptibility to the supposedly, quote, grave danger, end quote, the mandate purports to address. And of course, he's writing that in November of 2021, when back in the throes of the pandemic, the OSHA said, we don't think an ETS is appropriate or necessary at this time. Perhaps, again, we didn't have a vaccine then. Let's remember that. But there were standards that they perhaps could have imposed at that time that would have met that requirement. The judge does comment on that. But the change in direction even quoted the president when he said he was running out of patience. And if I were the petitioner's lawyers, I would be jumping up and down after reading this decision, because it looks like he agreed with every single one of their points on the arguments. And there's just nothing, he says the administration's prior statements further belie the notion that COVID-19 poses the kind of emergency that allows OSHA to take the extreme measure. So the court really hammered OSHA on this. And there's a comment here, something about, OSHA should stick with, monitoring hard hats and goggles and not trying to, get itself involved in healthcare policy. And there was just every element of the standard for injunction that the judge said was met. And he really drew a roadmap. He took the time to, and I think he understood where this case was headed, because this was the first decision published, to create the roadmap for other courts to uphold injunctions against the regulatory authority of OSHA. So that's the OSHA piece. Now, we have two other decisions that came out in the last 48 hours. One was the state of Missouri and 9 other states against the administration. This is what I'm going to call the CMS decision. Okay, and many of you know, those of you who are in healthcare, CMS is the Centers for Medicare and Medicaid Services. There was a vaccine mandate imposed there through something called an interim final rule. Okay, and this is an administrative agency that regulates lots of terms and conditions for the Medicare and Medicaid program, but has never in its history imposed a vaccine mandate, okay? And here, another example of regulatory authority being exercised and skipping steps. They called it a final rule, but they also used what they called good cause and said, due to the urgency of all of this, due to the urgency of all of this, we're imposing it now. And the federal judge in the Eastern District of Missouri just the other day on the 29th said, hooey, you know, back in 2020, you folks did the same thing and you told us this wasn't necessary and you're not involved in it. And by the way, you've never bothered to regulate the problem of flu in long-term care facilities. You know, the court in this decision, this is a 32-page decision. I didn't even get a chance to finish reading it today. Same elements, the irreparable harm, likelihood of success, and the judge in that decision said, if you're going to impose these kinds of standards, Congress must speak clearly to it. We do not have a federal law on this. Obviously, the pandemic, at least, was unprecedented since 1918. And what the court has said is, look, if Congress isn't speaking clearly to this, you know, you've got to have a really, really good reason, and you haven't shown it, okay? And it's not your bailiwick. So the Biden administration, which is seeking desperately through its own executive branch channels, that being regulatory authority, is striking out left and right in federal court. And I think we're going to see more. The other related decision was out of Kentucky, and this came out yesterday afternoon. And I'm just going to read the judge's decision just to show you where the judiciary is. Opening statement. This is not a case about whether vaccines are effective. They are. Nor is this a case about whether the government at some level and in some circumstances can require citizens to obtain vaccines. It can. The question presented here is narrow. Can the president use congressionally delegated authority to manage the federal procurement of goods and services to impose vaccines on the employees of federal contractors and subcontractors? That's the Kentucky case, the executive order, okay? In all likelihood, the answer to that question is no. So for the reasons below, the request for a preliminary injunction will be granted, okay? So, and in that instance, we had an executive order, one of the first ones, by the way, signed by President Biden, establishing the Safer Worker Federal Workforce Task Force. And they were to provide guidance. So you have a task force issuing guidance, and then a new executive order, September 9th, which was mandating that task force to provide guidance on adequate COVID-19 safeguards, okay? So again, we went through it, they issued guidance, we have the exercise of executive branch authority, it gets challenged, and it's now stopped. So now you have healthcare, you have contractors, and you have OSHA, all vaccine mandates, all issued under different levels of executive branch authority, okay, not congressional authority, being stopped by the judiciary. We're all learning a little bit about the three branches of government. And again, for nerds like me, this is wonderful stuff. I have no idea, you know, who won the lottery yesterday. So legally speaking, this is a trend. And there's also an issue here about the balance of power. I didn't get into the delegation doctrine, but the judge in the Missouri case talked about you're usurping states' police power to regulate health, okay? Healthcare policy, believe it or not, has traditionally been the purview of states' police power. We call that parens patriae. I get to throw a lot of Latin out today. And there are times when the federal government can preempt state law. You know, now I'm going to talk about preemption, and I joked with Laurel yesterday. This is going to be where all of you can check your email, go get a cup of coffee. This is completely boring, but federal government can preempt state law expressly, impliedly, and when there's a conflict, okay? So those are the three biggies, and conflict preemption is what applies here, okay? Because we have states who have promulgated no mask mandates or anti-vax mandates, and you have conflict. The question will be, has the federal government sufficiently enough taken jurisdiction over a particular subject matter such that it should regulate it to the exclusion of the states. A great example would be the Federal Motor Vehicle Safety Standards. Okay, we don't have airbag standards in the Commonwealth of Pennsylvania. They're regulated by federal government. Why? Because it's such a nationwide issue that the federal government has seen to it that the Federal Department of Transportation should promulgate regulations on all motor vehicles produced in the United States, brought into the United States, as it relates to airbags and or other safety standards. And that was litigated at one time too. So here, it's such a sensitive matter. The courts have pushed back. This is an example of the executive branch supporting legislation that didn't and won't get through Congress, relying on regulatory authority. Nothing new, by the way. Executive branches, presidents and governors have done this for many years. But in this instance, the president has gone to different agencies and they have combed through. In fact, the judge comments that they searched and searched and searched for legal authority to justify the mandate at this time, because they had evidence. And it's been a pretty good while since vaccines were approved under emergency use authorization, and you didn't have it back then. So tougher case for the administration to prove things. I'm sure the folks at OSHA, I meant to look up and see whether the person who issued the statement back in June of 20 is still employed, because the president and his folks are probably like, yeah, we wish you wouldn't have said that. But we're all learning that this is what happens. And guess what? Our judicial system works. Our system of government works. This is truly the check and balance that we've all learned about Schoolhouse Rock, okay? And you're seeing living, breathing examples of it. And the trend is that, at least as it relates to the OSHA mandate, I don't think it's going to happen, okay? All right, it's now 11:30. I've chatted for a bunch of minutes here. I'm not going to bore you all with the minutia. If anybody is curious about the court's decision and its legal impact on anything that you're doing, whether you're in any three of these categories, whether you're a federal contractor, whether you're a healthcare supplier, contractor, or whether you're an employer with over 100 employees, I'm happy to answer questions now or offline.
Well, Kevin, we'll let Laurel give her presentation, but I did want to touch on, so you kind of talked about it, the conflict between state and federal. So you're also seeing the Supreme Court reject some of the overtures. It was the Massachusetts hospital case just yesterday. So we're also seeing that the court is saying, while OSHA doesn't have the authority, or the feds don't have this authority via executive order, but an individual company has that authority to do it, or the state has the authority to make those decisions. And you're kind of seeing this, what the roadmap looks like as these yes or no decisions come down.
Yes, and so what we all should be doing right now is actually paying closer attention to what's going on in the Commonwealth of Pennsylvania. Okay, we know that in the mask mandate case, we have State Department of Health executive issuing a directive, which gets challenged, suspended, upheld. That's being litigated for the very same reasons we just discussed in OSHA. But the difference here is, I'll have to answer that in a second. The difference is the states do have the right to regulate health. And it'll be a question of whether the Commonwealth of Pennsylvania and its General Assembly spoke clearly enough. It'll be the same argument, same analysis, or is there sufficient enough authority granted to the executive branch and the Department of Health to regulate in this manner? That's going to be the fight.
Yeah, I think that's a key piece to watch, is as these decisions come out, everybody's looking at the federal level, but you really need to look at what the state level process is here, and as those decisions shape out, it's pretty interesting.
Yeah, just real quickly, I did run a check in the legislature yesterday. 2 bills in the House, which were opposing vaccine mandates. One will advance to the floor. The rest are sitting in committee. So really not much legislative activity moving forward on that score.
Are you talking about the constitutional amendment?
No. This is
Oh.
the I'm sorry, I had it here a second ago, the medical freedom bills.
Well, there's one of them is in the form of a constitutional amendment in the House.
Okay.
And that also, not only does that talk about the vaccine, it talks about vaccines, but it also exempts physicals, it exempts medical testing, but there is no exception in that piece of legislation. There is no, like, let's say I need to get a CDL and I need to get a drug test for that. There's nothing that's in there that would exempt. It says everything is blanket medical freedom. And that's concerning.
Yeah, that probably won't pass either.
It's not well written and it's a little concerning. But what we'll do is we'll I know we have some questions in the chat, and I've actually gotten some questions in advance, but we'll let Laurel go ahead and get back to her presentation on kind of how you approach this. Because, you know, as we're discussing it, we're discussing all the strange legal happenings, and we're nerds, so we enjoy reading this. Everybody else is reading fits and pieces and getting, you know, and gathering information, but might not be as in tune. So how do you work through this ever-changing process with your employees?
Trying to find my file here again. Hopefully it's going to be okay. So we're back to, oops. So what I was starting to talk about was really, you know, again, you know, as Kevin indicated, not something that I don't really think it's appropriate to be spending a lot of time to overly prepare for mandated vaccines when I don't think they're going to happen. What I do think is important, though, is that as an employer, as a private employer, you have an option to decide what you want to do in your workforce and what you want to communicate to your employees. And it is important, again, that employees know that you are concerned about their health, that you are concerned about their safety, and that you're making decisions that are in their best interest in terms of protecting their health. So, you know, if you choose to, from an HR standpoint, if you want to, or, you know, organizational standpoint, if you've not already thought about, you know, what type of internal process you would want to go to in terms of tracking status. I know I saw a number of individuals on the call that I know your organizations have already started to track vaccine status. That is something you're more than able to do. There's no, you know, legal implications to that. Although you will certainly have employees that push back. But, you know, make sure if you're going to do that, that you acknowledge and communicate to people what is fully vaccinated, what are you looking, you know, what's considered fully vaccinated, and what information you need from them. And also think about who and how you're going to track that. You know, the actual process side of, you know, how are people going to send you that information? Who's going to retain it? HR is obviously the most logical place for that because of the sensitivity of the information. Although, you know, vaccine status is not protected, you know, the status itself is not protected health information. On those vaccine cards and information that people share, there is some sensitive information, so it really should be maintained as you would any other protected health information. I don't believe, again, as Kevin said, I don't believe ETS is going to go through, but if it did, you know, some organizations have had people attest to their vaccine status. That will not be sufficient if ETS goes through. They want you to maintain those copies of people's, you know, vaccine record, both shots, or in the case of booster, the booster shot as well. So if it's something that you want to be, you know, very, prepared for, I think whatever tracking system you're going to use, it's wise to have a system that, records both doses. And, you know, potentially, again, if you think it's going to be mandated, most organizations are going to have the opportunity for medical and religious exemptions to make sure that whatever tracking system you're putting in place has the ability to note that you have an individual who has an exemption, so that you're able to, you know, track that in your system. Just, I was asked to talk about tracking and testing a little bit. There's so many tracking solutions that have been, I think as soon as, it's like a booming industry. As soon as the, we're going to have a vaccine mandate, you had organizations preparing for this from a, technical solution standpoint. At the end of this presentation, which I will send to Katie and ask her to share with everybody, there is information, I'm not going to go through it because there's multiple options in terms of testing softwares. What I suggest to anybody who's interested is, and by the way, for most of our, well, I shouldn't say most, many of our clients, they're already tracking vaccine status. So if this is not something you're doing today and you choose to do it or you want to do it for a variety of reasons, I encourage you to talk to your HRIS provider, ADP. I know like Paylocity, a number of the HRIS providers are putting together a template for individuals to use. Some of them have, reminders that they'll send out to employees about, hey, we haven't received your vaccine status. They're great. Ideally, you want a solution that's going to allow for employees to upload the information themselves. Some employers, Kevin talked about the regulation or the ETS being kind of a one size fits all. Hopefully you come up with a solution that is not one size fits all, because as we all know, some employers have employees in different states and different locations. It's not easy to say, oh, bring your vaccine card to human resources, because human resources might be hundreds of miles away. So ideally, you have a solution that meets your organization's needs based on what how you're set up as an employer. And I always think it's, most useful to have employees upload that information themselves. Now, some people will say, well, they can make up a card, they can do all kinds of other things. Yes, which is why you need to have a policy that says, it's a record. It's like any other, information you have as an employer. If you falsify that information, it's grounds for termination. That's really, that's really my best advice on that particular situation. If somebody, to me, if somebody wants to be that creative and go to the trouble of doing that, then, I've seen some interesting solutions that people have provided already. So I will say that there are definitely folks out there that are making it up as they go. But the testing and the tracking solutions are really becoming, there's quite a number of them to choose from. So I don't think you'll have any issue. Of course, doing the old Excel spreadsheet would work, but it's not ideal, because then you have to update it every time you have new employees and terminations. And it's having your solution be able to tie to your HRIS or speak to your HRIS is definitely the way to go. On testing, if you're not a healthcare related work employment situation, you don't have, most employers don't have relationships currently with testing facilities. If that's something you think is going to be advantageous to you at some point, and you want to start looking at that, that's certainly an option, because administratively, you can certainly send your employees themselves to be tested. Obviously, we're all doing that now when employees say that they've been exposed in most cases. But, post December 31st, employees will have to pay for those COVID tests in most cases. And that's going to become an issue from an administrative standpoint. And so if you choose to, as an organization, if you choose to, as an employer, say, we might be willing to pay for this because we administratively want to get those results ourselves or control that communication process, now's maybe the time that you want to think about, working on that and thinking about your internal process as it relates to testing. Is that, I think insurance companies have sent out information saying, after December 31st, no more free COVID testing. So that's going to be interesting, I think, just in general, to see how that plays out. So that's something to at least think about, I think, as the employer. If you've not implemented anything at this point and it's something you feel is important, you can consider incentives for vaccination. We have clients that have, encouraged people with time off. I certainly don't recommend that at the moment, given the staffing shortages everybody's having. I don't think time off is, although employees like it, it's not really practical at the moment. So monetary incentives. I know a number of employers offered monetary incentives initially and upfront, and then kind of stopped them. I am seeing a kind of a resurgence of, not so much for boosters, but definitely for getting fully vaccinated. Some employers I've heard of recently, $500 if you're vaccinated by the end of the year. I think that's pretty. It's a pretty nice, meaningful incentive. I'm not so sure, to be honest, that financial incentives are going to change people's perspectives. I do feel like most people, if they're going to be vaccinated, are already vaccinated. So the way I look at this is more like it's a nice bonus to give your team members, to kind of reward them for being vaccinated if it's something that they've done. Again, that's strictly based on what your organization chooses to do. And the other thing I think employers need to think about now is recommunicating and maybe rethinking, what your time off policies are in relation to vaccine time off, recovery for vaccinations, paid time for COVID, because of course, the tax benefit for that time is now expired. So as an employer, you're not able to be reimbursed for that. So, how do you want to approach that? If it's something you want to rethink at this point in time, are you going to pay for time off for boosters? Are you going to pay for recovery time for boosters? Those are things that if you haven't already determined or thought about, the things that you need to think about and address from a communication standpoint to your team members. The other thing that I've talked with employers about recently, that Kevin and I spoke about yesterday, that I think is just good practice, and I think could be helpful going forward, because sadly, I don't think COVID-19 is going to be the only illness like this we're going to be dealing with. But already, today there are a number of contagious illnesses that we want our employees to tell us about when they have them, such as the flu. We've seen recently a number of sports teams, particularly college sports teams, have been, practically taken out by the flu. We certainly want our employees to tell us if they have a communicable or contagious disease. And when I say tell us, by that I mean tell, employees, people who need to know, typically human resources and possibly a supervisor. If you don't already have a policy, I think it's a good practice to have a contagious illness policy. That policy should detail that your employees need to notify you when they've got a contagious illness or communicable, disease. That doesn't mean that you're going to tell them they have to stay home, but what it does mean is you need that information because it's a safety issue. Obviously, some communicable diseases are not going to be an issue in the workplace, because unless you're behaving in ways that are going to create some other issues, they're not workplace, they're not things you're going to pass on in the workplace. So you want to note in that policy that, work attendance or decisions about people continuing to work, with that particular illness are going to be based on, well-informed current medical judgments concerning that particular illness or disease and the applicable risk of transmitting it in the workplace. COVID-19 would be just one of the contagious illnesses that you would be outlining. In the case of COVID, the protocols are going to be consistent. Everybody's going to have the same protocols to follow. In the case of other illnesses, they're not going to be the same. And so you want to outline that in the policy as well. But if you don't have some kind of policy like this, you really have no way of enforcing your employees telling you when they're bringing something into the workplace that's going to potentially create problems for you as an employer. Not trying to create more work for anybody, but I do think from an employer perspective that this is, it's wise. It's a wise policy to have in place if you don't already. As far as the rest of my slides, they're all information on the various tracking systems that are out there. I'm just quickly, scanning through them. Again, I will put this in get this information to Katie so that she can get this out to everybody. And at that point, I'm going to stop sharing my screen.
Much appreciated. Thank you, Laurel. So I did want to say, and thank you to Kevin. This is your third presentation, so you're going for a hat trick with us by doing these this year, and it has been very interesting as we've gone. So we did February, and then September, and now in just the breadth and the depth of how much this has changed, and what you have to keep track of on a consistent basis. So, everybody else is kind of feeling a little overwhelmed with some of the content and just how some of this is. Don't feel bad. We're all in that position, just trying to keep track. So I put that out there as a, make everybody feel a little bit better.
Try being in HR through this, Katie.
Well, that's exactly. And that's the hard part is, I liken it to the Marshawn Lynch, I'm just here so I don't have to get fined. We don't like it either. So we have to do what we have to do. We're still in the position where businesses don't have COVID liability protection. And that had been something we've talked about from the beginning of the pandemic. So we're all still in this very nebulous space. And yes, we're talking about the vaccines, but that liability protection concern for businesses is still quite unanswered. There's tens of thousands of cases pending right now on those decisions. So it's still something you're going to have to combat with in the absence of real good direction.
Well, if I may, Katie.
Yes, sir.
My advice on this hasn't changed. And remember, we still have COVID-19 policies. Many of you out there implemented them for the very first time with COVID-19. And, the OSHA general duty clause still exists. The general duty of an employer to maintain a safe work environment. And as it relates to COVID-19, that standard is established by CDC guidance, DOH guidance. That advice has not changed, notwithstanding litigation that has moved through the courts. But Laurel's comment about having a infectious disease or communicable disease policy is very helpful, because I know many of my clients did not have that. Why? Well, we all kind of many thought common sense. You tell your boss you have the flu, it's contagious and you shouldn't come in. But what we did with the COVID policies is we imposed the duty on that employee to notify confidential, on a need to know basis, an employer representative of this particular contagious disease. So it's really important, because we want to make sure as employers that the employees understand they have that duty. We all know that we've had people come into work because they needed the hours and the cash, and they were sick as dogs, and they got the rest of the people sick. It's daycare syndrome. And getting the flu, by and large, most people don't die of the flu. If they got it in the workplace, they'd be ticked off at their coworker, maybe. But this is a disease that kills people. I had a client die yesterday morning in Penn State Health, and he was put on a ventilator the day before. He only made it 18 hours. And I won't get into detail, but this can kill people. And so as it relates to what you can do in the meantime, while a lot of this shakes out in the court system, is think about what your responsibilities are. And again, I think it's great to just remember there's a lot of contagious diseases out there, including COVID-19. And frankly, I think that takes the politics out of it when you're saying, okay, here is our policy. You need to tell us if you've got anything that's contagious, not just COVID-19.
And the other thing that's important is, the OSHA, if somebody's hospitalized, if somebody, heaven forbid, dies you still have you still have to report those things to OSHA if in fact the person contracted it in the workplace. So none of that has changed or gone away.
So hop into, and I think we've kind of answered this first question. The one question I got in advance was, there's a small business, they're under 100 employees, even though that's, the small business definition keeps changing. And they're curious as what they should be planning in regards to the vaccine, if anything. And I think that's the answer of, you should have COVID policies. This may not be coming down the pike, but you either need to have one or institute one as we go forward.
And you still, as the employer, need to make decisions about what you want in your workplace. Do you, masking, not masking, I'm not saying anybody's going to want to do this, but you could, in theory, mandate vaccines without having a vaccine mandate. I've not seen anybody want to do that, but as the employer, you have decisions to make for your employees.
Mhm.
Yeah, the employer can always impose a standard
Correct.
that is higher than what's mandated. Remember, on this very program months ago, vaccine mandates by employers were defensible since December of 2020. So one full year as of today, early in December of 2020, an employer could mandate that. So that door had been open a long time ago. Not many employers walked through it, but it's there. And as Laurel correctly noted, an employer can impose a lot of creative safety standards that, again, I'd say, remember your CDC guidance, stick with that. I think that helps keep your insurance in place to the extent that someone's going to try to make such a claim. The OSHA reporting requirement, it's very tough to prove. We still scientifically, no one has been able to prove, whether an employee contracted it in the workplace. I mentioned the meatpacking case in Bensalem. That involved absolutely no standards whatsoever in the workplace, and a bunch of people died. There's a ton of circumstantial evidence that the employer's staring down there on transmission, but it still hasn't been scientifically proven. And so you as an employer can stick with your CDC guidance, your DOH guidance, be creative, incentivize. All those things are really still at play. But for today's purposes, neither OSHA nor CMS nor the Labor and Employment Task Force have been successful in exercising executive authority to impose a vaccine mandate.
So next question, this is for Kevin. To confirm, did the judge rule against mandatory vaccines in the state of Missouri case?
The court in the state of Missouri case upheld the injunction. So yes, he stopped the requirement from going into effect. Now the Missouri case, just so that you understand, the Missouri case was the CMS case. So that was enjoining the category of vaccine mandates that applied to the broad definition of healthcare facilities. And in the regulation, there was 14 types of facilities and employers. And those of you who are in home healthcare, you were included in that under that definition. So that was limited to that category. And uniquely enough, I commented on long-term care facilities. The judge did say, we all know, and there's plenty of evidence that it was a problem and it caused deaths in long-term care facilities in particular. But this regulation was so broad, it also applied to teenage mental health facilities where there was absolutely no evidence to support the reg. And the court even said, had you limited this to long-term care facilities, we're not so sure you wouldn't have been able to prove it because you had a lot of medical evidence and trace evidence and case tracing. But to answer that question, I don't know in the state of Missouri if there was any other kind of mandate, but this was the federal mandate for healthcare facilities that's been blocked.
And that one, so I'm correct, that one right now is in the states that were part of the case. Is that a nationwide one, or is there? I think there's one of these that just applies to currently the states that were part of that were parties.
You're talking about the Kentucky one.
I'm talking about the Kentucky one. Okay.
Yeah, that was Kentucky, Ohio, and
yeah. There's and that's what one of the other pieces that some of this is marching through the process. So where does it apply right now? But kind of looking at long game, we expect it will be blanket, but there's still some additional hurdles to get through on. Does it apply today, or it might apply tomorrow?
Well, same procedural dynamic at play. In all the circuits, litigation has been filed. What we're seeing now is decisions coming out. And in some cases, for example, Missouri was Missouri plus 9 states, attorneys generals filed. Kentucky was a few others, but they'll follow the same procedural process. There'll be a consolidation, and it's ironic. It's literally a bingo ball lottery where a circuit court will then be appointed to hear all of them in that category. Okay, and you can expect the same process where there'll be a motion to have the whole court hear it, just to take a three judge panel out of the equation, and so we'll see more of it. But you know, these first hits have stopped it from taking place, and that's a precursor. Certainly, what you could have is this: you could have a different circuit, like in the Kentucky decision, because it's only 3 states. You could have a different circuit which has jurisdiction over a multitude of states come up with an opposing decision, and that in and of itself creates automatic Supreme Court jurisdiction. However, I expect procedurally there will be a consolidation first before appeals to the Supremes second. But you know, if I were a commentator being asked what do I think is going to happen, I think none of this is good news for the administration's efforts at mandating. You know, they started out encouraging, they didn't like the results. Now they're mandating, and they're using mechanisms that the courts have said, you just don't have that authority. That's not what this regulation or this agency is authorized to do. It's such an important topic. Congress has to speak clearly on it.
Yeah, and that was actually the standard that the Supreme Court ultimately ended up taking in the eviction moratorium case. So that was kind of a similar decision-making process. So that's, we'll continue to see, but I just wanted to check on that. Next question, Kevin, do you expect OSHA to use the emergency temporary standard as part of their enforcement strategy under general duty clause?
No.
No, okay.
Because the emergency temporary standard has to be an exigent. This could have been used, okay, at the height of the pandemic. Certainly there could have been something. I mean, theoretically, they could have used a mask mandate as an ETS. OSHA could have, okay, at the time. And the judge, you know, commented and saying, you know, back then you didn't think it was appropriate because it's a one size fits all. There's procedural and practical problems with enforcing it because of the different sizes and types of employers. And it just wasn't, you know, it didn't fit cleanly into their regulatory system back then. And that's when it was the height of the pandemic. So my answer is no, I don't think it will.
This is your hindsight is 2020.
Yeah.
So Laurel, question for you. Do you or anybody else that you might know of have a suggestion for a possible contagious illness policy template or something that could be shared?
Yeah, SHRM has a kind of a very brief template. I don't necessarily have a place to go for a template because what, you know, as we've been talking about, it's going to be a little bit dependent upon the type of employer. The one I wrote most recently was for a healthcare related organization. So that's going to be different than an organization who has employees who are in different kinds of roles. I think the points I made in the presentation are it can be very simple. It can be 2 paragraphs. I mean, it doesn't have to be lengthy. And you can reference, you know, specific procedures that might relate to specific illnesses like COVID. But it's going to be dependent on your workforce. You may want to include information in there about use of paid time off or lack thereof. Like, that's going to be dependent upon the employer's decision. So, you know, I guess short answer, I don't.
Mm-hmm. So we just had a comment come through that New York State has a template as it refers to the HERO Act. So that might be a good place to start in some language.
Yep.
You have to change up some of the references, but that might be a good place to.
I mean, I'd say Google it, because if you Google it, you're going to get some hits and kind of, you know, take into consideration what works for your workforce.
Mm-hmm.
You know.
All right, I did have a question come in from a company that was asking about, should this OSHA standard stay? They have, and so Kevin, I apologize, there's math. We process paperwork and paychecks for 900 different employees, but they're under multiple EINs. Trying to keep, they're also under, this is a workforce sharing company, and they can be at 500 different work sites. And so the question kind of becomes, sort of a who's on first, who's in charge of these folks. And I think that also can deal with some of the COVID policy questions of, if you're sharing employees, who's sort of the lead on what goes on. Is it where they are working, or who they report to, and how do you manage some of that?
The joint employer question did come up in the regs. There is commentary on that from OSHA on joint employer and shared employer issues. I don't have that answer in front of me, but I do want to mention this, and this is a timing question. Right now, as it exists, the regs were to go into effect next week, and based on the fact that OSHA has backed off enforcement, it is highly unlikely that if the full Sixth Circuit were to overrule the Fifth Circuit and therefore reinstate the ETS, it is highly unlikely that its effective date would remain. I am fully expecting OSHA to push it back and push it off further if they were to get a date, to get it upheld. The reason they haven't done so is because they got slammed by the judge for the delay they themselves imposed in the first instance. How can it be such an emergency and exigency if we've waited all this time? Okay, so they're not going to go out there and say, oh, by the way, if we lose, don't worry, or if we win, don't worry, we're not going to make you, put this into effect and be subject to fines that are out of this world. I don't expect that to happen. If anything, they've made it clear they're going to let this play out in the courts. And frankly, I'm not sure they're fighting that hard. Okay. But if they were successful, I think you'd have new guidance come out and a new rollout date. And, we might have another one of these calls to talk about exactly, what to put into effect and compliance. There's just nothing that I've seen here that leads me to believe the full Sixth Circuit is going to authorize this. And again, folks, this is just a question of, does an executive agency under all forms of rulemaking authority, do they have this authority? It's got to be expressly granted by Congress in authorizing language, and it's not there. It's not there. There is no law. There is no federal law on this topic, and the judges have taken great lengths to say, and there's a lot more reasons why you're wrong and why you're going to lose. And again, not that you all need to read these decisions, but these judges were thorough and banged away on every point why these were wrong. And when it comes to meeting the elements for an injunction, you have to meet all of them. But in the Missouri case, the judge reached a finding. He says, I've already concluded that this action by CMS was arbitrary and capricious. That's the legal standard for invalidating agency conduct. And he's saying, I've concluded they're going to lose at trial. And that's a pretty strong message. So, I think the White House and all of the executive agencies are going to have to figure out, a different way to, at least focus on vaccination in the workplace, because each one of these categories dealt with vaccination in the workplace, and they were way overbroad, outside the authority of both the legislation under their statutes and under the rulemaking authority. They're going to have to go back to the drawing board if they're going to continue to have executive branch governmental activity, on this topic. to me, I think they've hit the wall. And so those of us on this call and elsewhere, I think this fight's now going to go to the states, and we have to start paying attention to what's happening in the Commonwealth of Pennsylvania and pay closer attention to that, because I think the federal judiciary has spoken. The federal government does not, really have jurisdiction absent congressional authority. That ain't happening. And so we have to pay closer attention to Governor Wolf, the Pennsylvania Department of Health, possibly, our Department of Labor and Industry, and really they've let the feds take the lead. DOH has been active, but Pennsylvania Department of Labor and Industry, they've had little to no activity on these topics, and of course, they defer to OSHA on most of workplace safety.
Mm-hmm. And the mask mandate case is a good starter roadmap on some of that, especially when it was making that decision based on, does the Secretary of Health have the authority to issue these guidances in the absence of an executive order of emergency declaration? So that's going to be a key piece of distinction as how does this go forward, and that may change how that operates.
Yeah, and again, none of this prevents an employer from imposing, their own safety rules. I really think that with your employees and the fact that we're all just really in a tight labor market, keeping in touch with your employees is so critical, and sharing with them, educating them about what's going on and why it's important to maintain safety standards. You literally have a duty under federal law. Absent all of this nonsense in these three cases, the duty is still there to be safe.
I also did want to bring to the group, I know Laurel, you had touched on it, finding ways to make this a little bit more manageable, using technology to your benefit and leverage. I personally had a presentation with a group called Qualo Health Pathways. They're in Lancaster, and they have an electronic dashboard where your employees have an interface. It's all set up by levels of who's in your system and what they can see. It even has components for if you have medical staff on hand, but it can help you keep track of when there's exposure, when there's testing, who's out, what specific days if they're out. So, as Laura kind of talked about, there's a couple different companies that are out in the space. Got to kind of find what works for you, but best advice.
What you're talking about, Katie, is definitely more contact tracing, which is sort of different even than the tracking of the vaccination status. So there's organizations that do both. To your point,
you can and finding something that works, cost effective, but can help keep track of this and make this less of a headache than what it is. And it can be a paperwork nightmare if you're trying to keep it all, in a scratchbook somewhere. So that's, make the encouragement that if it's the right investment for your company, there are folks out there, and Qualo is the folks that I spoke with. They're absolutely lovely, that could help your organization be able to make this much more manageable and have that information at your fingertips by running a report, as opposed to trying to recreate emails and dig for things. So I think that's a good personal suggestion of trying to come up with some solutions that make this a little bit simpler for you and your employees. So with that, I don't have any other questions in the chat, but this has been, again, a good exercise to kind of talk through these interesting points. Kevin, we may or may not have another webinar. Who the heck knows? At this point, every time there's a rule change, I poke Kevin and go, hey, you got time? and Laurel, that it may include you as well, depending upon how some of this goes. Have always been appreciative of everybody who's been able to participate in this. Yes. Do want to, if there's any closing comments that you both want to give, and then we'll wrap up our event.
Good.
No, I mean, I think we've spoken through it. Pay attention to what's going on in state government right now. Pay attention to the news on these mandates, but I expect that the OSHA, the CMS, the ETS, I don't think they're going to go into effect. And they're all stayed as of today, but I just don't see it happening. There'll be more activity. The Supremes may end up taking it up, but hey, folks, it is almost Christmas. I don't know if they're going to get these and rule on them before the holidays.
Yeah.
All right. Well, thank you everyone for participating in today's session. We will be sending this out to anyone who registered. If there are any additional questions that you might have or things that you think up, please don't hesitate to send them in. I'll be happy to reach out to our experts and see if they can give some answers. And as things continue to shape up and as big decisions come down the pike, GRCA will make sure to keep you updated. Thanks so much, everyone.